In protecting the work you are creating now, the same rules that applied before COVID-19 continue to apply. Therefore, you could choose to regulate yourselves by means of an agreement, a contract, an agreement between you and the person you are working with, or an agreement between you and the person you are working for. You can have several forms of this kind of contract, the most popular of which would be one whereby you list the terms and conditions of your relationship and what will happen to the outcome of your work. A more simple kind of contract would be a non-disclosure agreement, whereby the main and usually only stipulation would be about keeping the project or the process by which the project is being created confidential and secret. Apart from contracts, we also have the intellectual property rights that would apply to the work being created. Naturally, this all depends on the kind of work that is being created, as different IP rights could apply to different works. We know that some intellectual property rights are automatic and therefore do not need any kind of registration, while others require an application for registration in order to grant rights. The automatic intellectual property rights are copyright, the unregistered design right, and the database right. The registered intellectual property rights are trademarks, patents, and registered design rights. Most commonly, with artistic work, we would be looking at copyright. So it would be important to include into this contract that you are going to have, either with the person you are working with or the person you are working for, some stipulations about what is going to happen to the work you are creating and which is protected by copyright. It is also very important that you understand that if you are using somebody else's work, you might need to clear the rights. If you would like to release online work that was previously performed and previously recorded, you need to keep two separate things in mind. First of all, with regard to the rights on the work itself, when I had obtained the right to perform this work, do I also have the right to record it and to release this online? What about the rights of the authors of the work? What about rights of the performers whose performance was captured on video? Perhaps there might be a producer's right, dubious, but it could exist. And what about the rights of the people in the audience who were filmed and whose images may now be shown online? The second part is about the recording itself and the rights to the recording itself. Did the person making the recording, shooting the recording, give the right for this recording to be shared in this way? Or was it only done under the express condition that you keep this for yourself as part of your archive? What COVID-19 has shown us is the importance of force majeure clauses in contracts. Naturally, every contract should stipulate what the subject matter is, okay, and any terms and conditions that go with it. So, deliverables, delivery dates, extensions or revisions, rehearsal times, that sort of thing. What about commitments for payment? That should also be into your contract. However, we mustn't forget to include clauses such as force majeure clauses, whereby if the attainment of the deliverables is frustrated in some way beyond the control of the two parties, there is some kind of rule that regulates it. For example, a rule postponing the delivery date, so that the contract remains in force but binds you to deliver it by a later date. It could also include rules about payment for work commenced but not completed. This all depends on the circumstances of the case, naturally, and with everything this will always be true. But you could always include that work done until that date is paid for pro rata.